Good day, Crime Talk aficionados. My name is Scott Reich, and this is Crime Talk. We have a great show for you today. First, Bryan Kohberger's attorneys tell the district attorney, give us the evidence. Richard Allen wants to leave prison and go to the county jail while he awaits for his trial. And then question, why are judges, and I have an example of a judge in D.C., but why are judges letting dangerous people out of custody? And this mom and school principal is having nothing to do with her husband's conduct involving school kids. Porch pirates must be stopped. I think I have an answer. And then finally, our dumb criminal of the day. Let's talk about it.
Hi, lawyer.
Good day, everyone. Thanks for joining us. This is Crime Talk. You know the drill. Subscribe if you haven't, like if you do, leave me a comment, hit that bell, and yes, you can listen to us anytime on any of your favorite podcasting apps. Before we get to the docket today, a couple quick announcements. That's right, it is Tuesday. So what does that mean? We are going live at 6 p.m. Mountain Time. Join us this evening. We hope to have you in the conversation. And hey, we will take your questions. I promise I'll take your questions. All right, let's go ahead and get to the docket for May 14th, 2024. And first on the docket is Bryan Kohberger. And Bryan Kohberger's attorneys are saying, give us the evidence. That's right. The team is requesting new evidence in the ongoing Idaho quadruple murder case. And the judge overseeing the case is expected to hold two closed-door hearings this week to discuss recent requests made by Ann Taylor, the lead public defender for Bryan Kohberger. And the hearings, which will be held today and then on Thursday, will have a significant impact on the case and how it will probably unfold from here on out. Now, Kohberger's attorneys are requesting new evidence related to the probable cause affidavit used in Kohberger's arrest, including cell phone tower data, a video of a vehicle seen near the 1122 King Road where the murders were committed, and the information regarding a test drive. So Ann Taylor has stated in her motions, the state knows full well what they have and what they're withholding from us. We don't know what they're not going to show, but we know they exist. Now, Taylor said that at a hearing as well as in pleadings. Now, of course, the Latah County prosecutor, Bill Thompson, who's obviously leading the case against Kohberger, has rejected Taylor's claims that the state was concealing evidence. The characterization that we're just consciously withholding information to frustrate the defense team is utter nonsense, Thompson has stated. And he says that, listen, this is not true. We will provide everything that we can that is provided to us under the rules. Now, the defense is set to have two expert witnesses lined up for today's hearing. And that hearing is closed at the prosecution's request so that they can discuss specifics of certain evidence, some of which may not necessarily be presented at trial. Thursday's closed hearing will focus on the defense's request to review protected content regarding the investigative genetic genealogy records. The records were used by the FBI to identify Kohberger as a suspect, and the technique utilized DNA from a crime scene using public genealogy websites, which can help investigators determine potential suspects. And there is simply no legitimate reason that the way the IGG procedure in the case took place should be shielded from the public, the defense is arguing. This court has provided no authority for sealing those materials. So the defense clearly wants this information out in the public. So at that hearing on Thursday, the defense will call at least two witnesses, and they have several exhibits for that particular hearing. Now, last month, as you may recall, Kohberger's defense team filed a motion providing new information on an alibi where the defense planned to call Cy Ray, a former police officer who specializes in analyzing cell phone data in criminal cases, to serve as a defense witness and expert, and to dispute some aspects of the cell phone pings, including those pings that were identified in the probable cause affidavit. Now, the alibi motion said that Ray will testify that Bryan Kohberger's mobile device was south of Pullman, Washington, and west of Moscow, Idaho, on November 13th of 2022. That Mr. Kohberger's mobile device did not travel east on the Moscow-Pullman highway in the early morning hours of November 13th, and thus could not be the vehicle captured on the Moscow-Pullman highway near Floyd's cannabis shop. The affidavit also alleges that Kohberger's cell phone pinged near his off-campus Washington State University apartment at 630 Northeast Valley Road at 2:42 a.m. on the night of the murders, and was later seen on the surveillance footage from the Washington State University traveling north on Southeast Nevada Street at Northeast Stadium Way. Now, as you know, the trial date has not been set yet again. Hopefully after these hearings, we'll see how much time will be needed, assuming the court grants the defense request, stating that, yes, we believe this information is out there. The prosecution just needs to get it. It's in their care, custody, and control, and therefore we need time to obviously review it, analyze it. How does this engage? How are we going to use it to engage in motions practice? And how does it affect the overall strategy of the case? So hopefully that will be done. Once again, huge disappointment that the hearings will not be televised. I have said this repeatedly. These proceedings should be televised. I am a firm believer that all proceedings in the judicial system should be televised. It is a public courtroom. The public has a right to know what is taking place. There are other hearings that are going on, trials that are taking place where they should be televised. It lets the public know exactly what's taking place, and they can see with their own lion eyes whether what is being told to them is the truth or not, and they can decipher and say that is not admissible or it shouldn't be considered. It'll never come in at trial. It happens every day in courtrooms all across the country. Judges decide what evidence is coming in and what evidence is not coming in. And anybody can walk into that courtroom and sit there and observe. And to think that this case is somehow so special, routine procedures need not be followed, makes no sense to me whatsoever. Next on the docket, Richard Allen wants to go home, well, at least as close as he can to the county jail. Well, the attorneys for the Delphi murder suspect, Richard Allen, have launched a new campaign to have him moved from the state prison to a county jail. In some recent pleadings, Allen's attorneys are asking Special Judge Francis C. Gull to move Mr. Allen to either the Cass County or the Tippecanoe County Jail while he awaits for his trial, which was recently moved to October. Now, Mr. Allen was moved to the prison for safety reasons early on in the case, but now the sheriff has apparently made plans for Mr. Allen to stay in the county facility during the October trial. Now, obviously, if you watch this show on a regular basis, you know Richard Allen is accused of the 2017 murders of Libby German and Abby Williams. Also in the new pleadings, the defense team asks for more money to keep a third attorney on the case full-time. No indication on when the judge will get around to deciding whether that third attorney should remain. But as you know, there was issues with the judge not signing any of the attorneys' bills for them to get paid, basically making life miserable for the attorneys. Judge Francis C. Gull despises the defense attorneys in this particular case, so I'm assuming that she will drag her feet on this request as well. But we do know that the case is scheduled for, once again, a 3-day hearing beginning on May 21st and going through May 23rd. Obviously, we will provide complete coverage. And unfortunately, once again, a judge has decided that this case is just too sensitive, that we, the public, are all just the biggest bunch of buffoons, the biggest bunch of hayseeds, and we can't figure out these big, fancy legal ways to figure out and judge for ourselves if these proceedings are fair and what evidence is going to come in. I don't get it. I really hope the judicial system wakes up to allowing cameras in the courtroom. Next, why are judges letting dangerous people out of custody when they are arrested on a new case? Why are judges giving bond? Let me tell you generally. I have friends that are judges. Some of their worst nightmares, what keeps them up at night, is whether their name is going to appear on a headline somewhere that they let somebody out of custody or gave them a chance on probation, and they go out there and they commit a worse or even more heinous crime. That is a judge's fear. Most judges are going to take a very conservative route, which is, well, gee, you're charged with a violent crime or involves weapons, you're a danger to the community, potential flight risk, we're going to set your bond so high that you cannot get out. And if you can get out and make bail, that the bail is going to be high enough, there's going to be enough property that you're probably not going to screw your family by skipping town and your family's going to lose their house. That's usually the way it's done. Then I'd say over the last 5 to 6 years, most states are getting away from this bail system where you can actually pay a bail bondsman. Now, I assure you, bail bondsmen, they made sure people returned to court. Now, not so much. A lot of people are getting PR bonds, but you're seeing a little bit of a shift away from that, where everybody was getting PR bonds or very low bonds. You're seeing a shift away from that because people are realizing it doesn't work, and prosecutors don't want to have their names on those headlines, just like the judges worry about that they are going to let somebody out and they commit a new crime. The bail bondsmen were the people that made sure people got to court, because the bail bondsman was on the hook financially, and they'd rather go turn that person in to the court and not have to pay the court any money. It's that simple. So now we got away from that. Everybody gets a PR bond, and then, and I dare you, somebody show me the number that it exists, and I will admit that I'm wrong, but I don't think I am. When somebody fails to appear in a PR bond, let's just say, for example, the judge sets a bond at $1,000. And the promise is that you have to appear in court. If you fail to appear, you're going to owe the court $1,000. Show me anywhere where anyone has ever paid that money to the court for failure to appear. They have not. How much money has ever been collected on PR bonds where people failed to appear? Zero. Somebody wants to produce evidence of the contrary, let me know. All right, to our next story. Judge's worst nightmare. Public scrutiny that they messed up, but some judges just don't care. And what is being called a woke judge in Washington, D.C. is facing some backlash after he opted to cut loose an 18-year-old man accused of firing more than 24 rounds from an AR-15 style rifle into a car full of people. I think most people would say that is a dangerous person, but apparently not to Judge Lloyd U. Nolan Jr., a judge on the Superior Court of the District of Columbia. Last week ordered Amonte Moody to be released on house arrest ahead of his trial, despite acknowledging the teen's alleged actions, could have killed somebody. Now, Mr. Moody, the defendant, who was slapped with the charges including assault with a dangerous weapon and allegedly sprayed 26 shots at an SUV carrying 4 people on Independence Avenue in the early morning hours of April 22nd. Now, Judge Nolan's decision to still grant the teen pretrial release in the face of the alleged crime quickly sparked some outrage on social media, with many accusing the judge of being the George Soros puppet and pointing out his woke online posts. Now, the Facebook posts the judge has previously shared include a meme back in 2019 declaring that he was still woke, as well as other memes promoting Black Lives Matters. He was also previously posted a link showing he donated to the Gideon's Promise fundraiser in 2020, a group founded via fellowship from George Soros and his Open Society Foundation. Now, the judge's social media account has now been switched to private as the backlash against his recent decision is mounting and drawing more scrutiny. And Judge Nolan decided to set Moody free on house arrest despite the judge finding probable cause existed on the case. And the judge also repeatedly agreed with prosecutors about the severity of the teen's alleged crimes. The concern I have is that the actions could have killed someone, the judge noted on the record. And Moody's public defender pushed for GPS monitoring and insisted that the teen had a supportive family who were willing to keep the tabs on him ahead of trial. Of course, begs the question, where was the family when he was out spraying a car full of strangers, 26 rounds of bullets? Always the question that judges should ask. I appreciate your family showing up here in court today, but I think it begs the question, where the hell were they when you were out committing the crime? And you certainly weren't thinking about your family when you were committing the crime. Were you, Mr. or Miss Defendant? No. Anyway, when the prosecutors pushed back, arguing that those options were available to Moody prior to his alleged shooting spree, the judge agreed. But for something to escalate to the point where you feel you need to go into the middle of the street and let off 26 shots, I don't know what set of circumstances short of incarceration I can find, the judge said on the record. But despite that, he had concerns for the safety of the community. The judge eventually relented, and Mr. Moody was released to 24/7 house arrest, with a GPS ankle monitor at his stepfather's house in Maryland. Now, prosecutors with the United States Attorney's Office in D.C. have filed an emergency motion to reverse the district court's judge's release and have him remanded to custody. As a defense attorney, you always like to have your client out on bond. It's so much easier to communicate with them, get them to your office to go over to discovery, talk about things, and not go to a jail. But as a member of the community, I would be outraged and shocked that the judge let that individual out. I just don't get it, ladies and gentlemen. I don't. And as a member of the community, it's stuff like that that shocks me, even as a defense attorney. Next, this wife and school principal wants nothing to do with her husband and his little escapades. A Texas school principal's husband has been accused of producing child abuse materials on school grounds and then distributing them on the dark web. Gee, is that illegal? Oh, yes, it is. Yes, it is. It's very illegal. It's weird, it's dangerous, and just creepy. Please meet James Stone. Now, he was a teacher at the Thompson High School in Katy, Texas. And guess what? He was taken into custody on Monday on 10 counts of possessing and producing what police say are thousands of images involving minors. A teacher, a male teacher at a grade school possessing photos of children. Oh my gosh, hold on. Here comes my shocked face. Do I look shocked enough? Okay. How many times? And I'm sure there's great teachers, right? I get it. I get it. I get it. How many stories have we brought you, ladies and gentlemen? When are people going to learn? There are just certain rules that have always existed. And, you know, I had a guy once. The guy was working on a PhD in education. And shockingly, it came out that he was touching all the little kids at the grade school that he taught at. And everyone thought he was just a great teacher until something inappropriate happened. And all of a sudden, then all those little hugs and little pats on the bottoms, everybody realized was, oh, not right. And guess what they found at home? That's right, a bunch of images. In an effort for everyone to be just, isn't this great? And everyone should be able to do what they want? No. Wouldn't put my kid in that class. Nope, wouldn't do it. Maybe it's just my anecdotal experience with male teachers in grade school as representing them as an attorney. I don't know. I'm just telling you, ladies and gentlemen, it's common sense. Now, I'm sure somebody will say, oh, Scott, I had a teacher that was a male in grade school and he was great. I'm sure he was. Oh, well, I digress. Anyway, the police say that the 53-year-old teacher admitted to producing images, some of which were taken on school grounds. He apparently was quite well known for also taking images at various local swimming pools and other places in Katy, Texas. Anyway, the police claim that ultimately the images were distributed to the dark web. Gee, I wonder who wanted those on the other end, and why do they call it the dark web? Well, Melinda Stone, Mr. Stone's wife, and the principal at the Taylor High School knows what was going on. At least now she does. Anyway, she wrote 2 emails to the school community following the arrest of her husband and let everybody know she was cutting ties with her husband. In 2 emails to the parents, one to the parents and staff and another just to the staff, she confirmed her knowledge of the charges and announced that she was disavowing her husband, with whom she said he did something disgraceful. And in her letter to staff, the principal wrote, I am sure that many of you are aware of the incident involving my husband, James Stone. James was arrested this morning of possessing pornographic materials. His arrest and involvement in the criminal activity was unbeknownst to me or those closest to him. My family and I are deeply disappointed in his actions, and thus we do not have any plans to be involved in James' criminal proceedings as he navigates these next steps. It's also important for me to confirm with you that I, nor any of other family members, are implicated in James' criminal activity. And because this incident is still being investigated, law enforcement agencies are unable to provide additional information at this time. But I know that the district and I are taking this incident very seriously and are fully cooperating with law enforcement. Good for Mrs. Stone. She's doing everything right that she needs to do. She could say, oh, this is my husband's friend, but she's not. She's like, hey, this is weird, creepy, didn't know what was going on. Clearly this guy's got some issues. Now, we'll give him the presumption of innocence, of course, but let's face it, when he admits that he was doing stuff at school, just, ugh. Anyway, good for her. Disavowing him, let him go on this new journey on his own. And a journey it will be. A journey it will be. Next, Porch Pirates. We got to do something to get rid of them, okay? Porch Pirates are just nasty little thieves. They're like little flies that swat you, that you have to, they're like little flies that you have to swat at, okay? Now, the lovely Miss Kristen and I, if we order something online, we have it shipped here to the office. Why? Because we've had porch pirates steal stuff from our porch. Literally, they follow behind the delivery truck and they snatch it up. And at one point, some very expensive items from a store, I believe, called Neiman Marcus, took several items that the lovely Miss Kristen had ordered. Not sure what they were going to do for them, because I doubt that these porch pirates had as good a taste as the lovely Miss Kristen did. But the reality of it is these people need to be stopped. And in that little story, couldn't believe it, but the store was like, we'll send a replacement immediately. Unbelievable. So, yes, Neiman Marcus, needless markups, whatever they call themselves, but they got great customer service. Anyway, how are we going to get rid of them? I'm saying deadly force. That's my suggestion. But let's take a look at this video here. These porch pirates stole a package worth thousands of dollars right out of the hands of the homeowner, and it was all caught on this Ring camera. Look at this bold move. The man's running up to the garden path moments after the delivery has been made, and just as the victim, who is referred to as Henry, stepped out onto his porch to retrieve the parcel, the thief was sprinting up and intercepted it. Now, Henry, the victim in this case, believes the thieves knew what the package was about because it was iPhones that he knew what was in the package. Because apparently just after the delivery had been made, he received a scam phone call telling him to return the phones. When he said they had just been stolen, the caller hung up. Kind of weird, don't you think? Well, Henry certainly thought they were. Now, I had a case. These people are sophisticated, okay? I had a case years and years ago where packages would be delivered to a residence, and someone would be there when they knew that the package was going to be delivered. And what it was somebody had stolen somebody's credit card information. They would order new computers. The organization would have people wait at the house when the delivery was supposed to come, get it, and they would ship, in this case it was computer items, laptops, back to Russia. But the people in Russia were the ones that were ordering the items with the stolen stuff to have them delivered to the residents of the stolen credit card, where they had somebody waiting there to pick them up, ship them back to Russia, and or sell them and send the money back to Russia. That is sophisticated stuff. Now, do I think these iPhone guys are that sophisticated? No. But the only way you're going to stop these people, ladies and gentlemen, is deadly force. Now, that may seem a little extreme, but I think we will see the decline in personal property being stolen go down so quickly. People say, why didn't we do this sooner? And I always think about it. You know, we live here in the West, and I was watching a movie the other night about Wyatt Earp. And at one point, Wyatt Earp in his younger days was accused of stealing a horse and beating a man up to take his horse, and that he would have been hung for taking a man's horse. You don't take a man's horse. You don't take somebody's personal property. Now, over the years, we've said, no, we are too sophisticated. We are not going to allow people to use deadly force to take property because it is just stuff. But it's your stuff. And why should people have to take your stuff and you're the one that gets to be the victim out of it? I don't get it. Anyway, that's my suggestion. Let me know if you think that's a little too extreme. I think people's tolerance for the lawlessness is coming to an end, ladies and gentlemen. I truly, truly do believe people have had enough. And speaking of lawlessness, let's get to our dumb criminal of the day. So, police responded to a Wawa. Is that how we pronounce it there, Frank, the hardest working man in show business? Wawa convenience store in Fort Pierce, Florida, in reference to somebody that was back in the store who had previously been ordered trespassed. Now, since the trespass was still active, police arrested Joseph Delaney and placed him into handcuffs. Now, during that detainment of Joseph, he was holding half of a cheeseburger, according to the police reports. And after being provided demands to drop the burger, he refused. Well, apparently once the handcuffs were placed on him, Joseph forcibly threw the half burger onto the right leg of the police officer noting that there was burger residue on the thigh of the officer. Well, now Mr. Delaney has been charged with trespassing and misdemeanor battery on a law enforcement officer, a felony. He's locked up in lieu of a $10,000 bond. Now, Mr. Delaney has an extensive rap sheet. Shocking, correct? Oh, let's see what it's got. Attempted murder. Fraud, aggravated battery with a deadly weapon. Surprising. Now we can add assault on a peace officer with a cheeseburger. Anyway, he was also arrested in 2022 for striking a police officer with a metal pole. That was back in 2022. Now, where I come from, my jurisdictions, you hit an officer with a pole, you're going to go to prison, and you're not going to be out. When you do this in 2022, you're not going to be out in 2024. Oh no, you're going to prison for a long time. Anyway, as it relates to this case, Mr. Delancey, you are our dumb criminal of the day. Congratulations, you made it. It could have been a simple trespass, pay a fine, but no, you took it to the next level. Now it may seem ridiculous hitting the police officer, but you didn't have to do that. And so for that, Mr. Delancey, you are the dumb criminal of the day. Congratulations. You made it. All right, just a reminder, join us tonight, 6 p.m. Mountain Time, going live. We'll take your questions. Patreon will take your calls. And, of course, we'll ask the Magic 8 Ball the question of the week as well. Please join us, 6 p.m. Mountain Time. Have a wonderful day. And remember, the Constitution does matter.